What's going on? What's going on, world? I'm back at it. Just show you what I see right now. Boom. Boom. And you're live here for the deep dive, okay? I talked about this just a little while ago. I couldn't get it to work on the StreamYards. But I want to let you in on just, you know, all the details so that you have a better idea on what's going on. And that's what I'm about to take you through right here.
Imagine a person's life just turning into this relentless legal battle. I mean, escalating from local disputes all the way up to allegations of a federal state conspiracy. And all this, apparently, after a seemingly simple request for public information.
It's quite a scenario.
Yeah. What if the very systems, designed to uphold justice and transparency could actually be, as the sources we looked at allege, misused to silence someone?
Hmm.
Today, we're taking a deep dive into the, extraordinary timeline of events surrounding an individual named Matthew Reardon. His attempts to seek government accountability, as documented in the materials we've reviewed, reportedly spiraled into years of just systemic, legal, and personal challenges.
That's right. And our mission today really is to pull out the most important nuggets of knowledge and insight from the sources we have. We want to paint a comprehensive picture, as best we can, of the alleged constitutional and civil rights violations Mr. Reardon faced.
Right.
And this isn't just like a dry legal rundown. It's a journey through a real-life legal saga. It's filled with, frankly, surprising facts and crucial insights into the mechanisms of justice and how they can, at times, reportedly be, well, perverted.
And the sources for this deep dive are pretty illuminating. We've gone through this meticulously detailed timeline of events, spanning years of this unfolding narrative.
It's a lot.
It is. And alongside that, we have a strategic legal memorandum. This thing painstakingly analyzes the potential claims and legal theories involved.
Yeah, it lays out the arguments.
Exactly. These documents give us a deep, deep look into the allegations. It's like a unique window into the complexities of government interaction and individual rights. It's a striking case study in persistence and, as the sources allege, systemic pressure. So let's unpack this.
Let's do it. To really understand the gravity of what reportedly transpired, we need to start at the beginning. We need to understand the foundations of this conflict, the pre-2017 events, and the initial incidents that kind of set the stage for such a prolonged legal struggle.
Okay, so who is Matthew Reardon? The sources give us some background. They note his service in the U.S. Marines from 2007 to 2011.
Right.
He received a general discharge under other than honorable conditions, which the documents link to alcohol-related issues.
Okay.
After his military service, he went into the civilian workforce. First as a trainer for Smart Circle New Element INC for about 7 months, then with Centex Solutions starting in November 2012. And by 2016, he was self-employed, started his own company. So you see some entrepreneurial drive there.
Yeah, and alongside his professional life, his personal life also had some significant developments that, well, they'd become very relevant to this story. He had a child, Lydia Elise Reardon, born August 19, 2014, with Phyllis Marie Crowder.
Okay.
The sources note they weren't married. In this family context, it becomes relevant pretty early on. In August 2016, there's a court order in Lafayette County Chancery Court about child support between Matthew and Phyllis.
Right.
And their daughter Lydia started residing with Phyllis Crowder at an address in Water Valley, Mississippi on July 8, 2016. So, we see the foundation of a custody arrangement already in place before things really start to heat up.
That sets the personal stage. Then, May 2017, this is where we hit the first major public incident, what the sources call the first spark.
Yeah.
On May 1st, 2017, Matthew Reardon held a peaceful protest on public property in Lafayette County. He was holding the Mississippi state flag.
Seems like a pretty straightforward exercise of First Amendment rights, wouldn't you say?
You'd certainly think so,
Yeah.
absolutely. But here's where the narrative takes a sharp turn, according to the documents. Deputy Timmy Pruitt reportedly confronted Reardon,
Okay.
kept asking for a permit, even though, as the sources note, there's constitutional protection for that kind of activity on public property.
Right, no permit needed. Exactly. When Reardon asked for Pruitt's badge number, the deputy allegedly threatened to arrest him for disorderly conduct. And he was in fact arrested. Charges were disorderly conduct and resisting arrest. Then he was booked into the Lafayette County Detention Center.
And almost simultaneously with that arrest, right, the documents highlight another legal action was happening.
Yeah, it's remarkable timing.
A temporary restraining order, a TRO, was signed by Judge Event against Matthew Reardon. This was requested by Mona Pittman on behalf of Phyllis Crowder.
Mm-hmm.
Now, that order was later found to be procedurally defective. That's an important detail.
Very important. Defects in procedure can invalidate these orders.
Then, a week later, May 8th, 2017, Deputy Shaquille Williams gets a call about Reardon trying to retrieve his state flag from someone's house.
Okay.
The very next day, May 9th, a new restraining order concerning their minor child was entered. This one was also later annulled.
Another one annulled. Okay.
And a hearing on that TRO was set for May 10th. It's just this rapid sequence of events, all centered around this one guy, coming just days after a peaceful protest.
It's a remarkable confluence of events, isn't it? It really suggests a high level of scrutiny on Mr. Reardon right from the get-go.
Yeah.
And the narrative continues to unfold with another public confrontation. On May 16, 2017, Matthew Reardon tried to address the Oxford Board of Aldermen.
Okay, trying to use official channels.
Exactly. He wanted to speak about the state flag incident and other grievances. The sources say he had reportedly complied with the procedural rules to speak, trying to do it the right way.
But it didn't go smoothly.
Apparently not. Mayor Pat Patterson reportedly prevented him from speaking. Just abruptly adjourned the public comment section of the meeting.
He shut it down.
That's what the sources state. Reardon then criticized officials as cultural Marxists as they were leaving.
Okay.
And Mayor Patterson ordered him to leave the building, and he was escorted out by Oxford police.
So you can clearly see a pattern emerging here, based on these documents. Mr. Reardon engaging in what he believes are his protected rights, peaceful protest, trying to address public officials,
Right.
and then facing these immediate sharp repercussions from local authorities. This escalation, it's a critical early indicator in the story the sources tell.
It absolutely is. This pattern of a citizen attempting to exercise rights and then allegedly facing immediate governmental pushback, it sets a concerning tone.
Yeah.
And this brings us to what the sources identify as the core allegation. The Freedom of Information Act, or FOIA, requests, the threats that apparently followed, and what became his first felony arrest.
Okay, so this is pivotal.
Pivotal. This isn't just one incident. It's arguably the fulcrum on which this entire narrative, as presented, seems to pivot.
Right, and what's truly astonishing here, a key insight from the sources, is how this whole saga, according to the documents, really centers on Matthew Reardon's Freedom of Information Act request.
The FOIA request.
Yeah. Specifically, April 26, 2017, he submits FOIA request, Don USMC 2017-000533 to Marine Corps Base Quantico. He's looking for standard operating procedures, SOPs, for Marine Combat Training East.
Okay, specific documents.
His initial contact was with First Lieutenant Talia Bastian. The sources emphasized this was protected First Amendment conduct, the right to petition the government.
That's a critical legal point. It's protected activity. And the story takes a really dramatic turn on May 25, 2017.
What happened then?
Reardon escalated his advocacy. He sent a final demand to First Lieutenant Talia Bastian, threatening legal action against HQ Marine Corps Quantico if that FOIA request wasn't completed by 3 p.m. the following day.
Wow, an ultimatum.
Pretty much. This ultimatum, as the sources highlight, seems to set the stage for the alleged retaliation. It's him basically saying, look, I'm serious about my right to this information, and I'll use legal means if I have to.
Now, hold on to that date, May 26, 2017, because the timing here, according to the sources, is extraordinary.
It really is.
At 9:13 a.m. on May 26th, that FOIA request, Don USMC 2017-005333, gets a response. Final disposition. Full grant. From the Quantico FOIA email address.
Full grant. So they gave him the documents.
All requested Marine Combat Training SOP documents were reportedly provided. That's a successful FOIA request. His demand was met.
Okay, so success on the FOIA front. But then,
what's truly astonishing here and a key insight is the alarming temporal proximity.
the timing.
Later that very same day, Matthew Reardon was arrested and booked into Lafayette County Detention Center for aggravated stalking, a felony related to a man named Todd Lynch.
The same day. Felony arrest.
Reardon claims this arrest was a setup, that he was framed. The sheer speed of this alleged retaliation, less than a day after his direct challenge to the Marines. It serves as a chilling testament to the alleged power dynamics at play.
It's not just a coincidence, is it? It raises this profound question. How quickly can a citizen's protected action allegedly trigger such a disproportionate systemic response?
Wow. So yeah, on its face, that timing is highly suggestive. But what was the official reason, the background, for this stalking charge? Could there have been legitimate cause, or was it pretextual?
Well, the sources indicate that on May 24, 2017, investigator Jarrett Bundren of the Lafayette County Sheriff's Office got a phone call. The call reported Matthew Reardon making threats towards Todd Lynch on Facebook.
Okay, so there was a complaint.
Right. Bundren reviewed Reardon's Facebook page and allegedly saw videos and posts of Reardon with guns, quote, verbally making threats. Todd Lynch then filed charges. So the charge appears to have some basis in a complaint, but Reardon claims it was fabricated, or at least twisted, to justify the arrest right after his FOIA success.
And amidst all this, other significant details emerge that further complicate the picture.
Yes. On May 24, 2017, the same day investigator Bundren got that call about the Facebook threats.
Okay.
Matthew Reardon visited the U.S. Attorney's Office in Oxford, Mississippi. He went there to report what he saw as systematic constitutional violations and also a death threat made against him.
So he was reporting threats against him.
Correct. The following day, May 25, the FBI interviewed Reardon. He apparently produced evidence of a death threat and discussed information on someone named Rhea Tannehill.
Okay, and what happened with that FBI interview?
Well, this is crucial. The sources state that the 302 form, that's the FBI's official report, summarizing an interview from this FBI interview, and any video evidence provided are later reported missing.
Missing, like gone.
Missing. Gone.
Yeah.
This alleged disappearance of critical evidence is a very serious claim. It really suggests, if true, a deliberate effort to suppress information that might have helped Reardon or implicated others.
Wow. Okay, also relevant to this period, right? There was a drug test.
Yes. His hair follicle drug test results from May 24, 2017 came back positive for marijuana and alcohol. This test was something he'd agreed to with Phyllis Crowder back on May 18th, related to their custody situation.
Got it. And he also bought a rifle around this time.
Correct. Just 4 days before the stalking arrest, on May 20, 2017, Reardon purchased an AR-15 rifle from an individual named Larry Watkins. So you have all these elements just converging right around the time of the FOIA threat and the subsequent arrest. It's this complex web of seemingly disparate events forming the backdrop to the felony charges against him.
It's a lot happening all at once.
It really is. And this complex web then leads to what the sources describe as a coerced plea and release dismissal agreement.
Okay, the plea deal.
Matthew Reardon had his initial appearance before Justice Court Judge Carolyn Bell on May 30, 2017. This was about 96 hours after his arrest.
Right.
Judge Bell reportedly advised him of his right to remain silent when he apparently tried to present exculpatory evidence that might clear him. His bond was set at an unusually high $150,000. Reardon stated this was 3 times higher than the maximum guidelines allowed for the alleged crime.
$150,000 bond for stalking? That seems steep.
It does seem unusually high based on the context provided. And then, according to the sources, on that very same day, May 30th, 2017, Rhea Tannehill allegedly threatened Matthew Reardon in a courthouse hallway, allegedly said, "I'm going to bash your head in," and tried to charge at him before being restrained by a Major John Hill.
Whoa. In the courthouse.
In the courthouse hallway. This is while he's dealing with this huge bond and trying to present evidence in what he feels is an unfair legal process. The tension, I mean, even just reading the timeline, it's palpable.
Yeah, definitely.
So a motion for a writ of habeas corpus, basically asking for a bail reduction, was filed on Reardon's behalf on June 5, 2017. It alleged illegal confinement due to excessive bail.
Did it work?
The petition was approved to proceed in forma pauperis, meaning he didn't have to pay court fees on June 7, 2017. But Reardon states he wasn't even informed of this approval.
Hey, hold up, folks. We got action right here. I had to pause that for a second. Timeout during the deep dive. Damn, they got 6 of them there. What's the deal with the big police presence for a traffic stop? They saw a man with a camera. Well, that's it. Sorry for interrupting that, but you know me, I see blue lights, especially if they're right across the street from me. I'm going to. I'm gonna go to them. Let me unpause this from where it left off.
Really? Why wouldn't they tell him?
That's a good question. It suggests, again, this pattern of alleged procedural missteps, or maybe deliberate omissions, further hindering his ability to navigate the legal system effectively.
Which brings us to July 6, 2017. This is a pivotal date, right? This is the guilty plea.
The guilty plea. Matthew Reardon pleads guilty to aggravated stalking. He claims this was under duress and coercion, based on advice from his attorney, Brennan Horan.
And the sentence.
5 years supervised probation. Banishment from Oxford and Lafayette County for 5 years. And critically, signing a covenant not to sue.
Not to sue who?
Not to sue Lafayette County,
Right.
the city of Oxford, their officials or employees, Sheriff Buddy East, or the alleged victims, Todd and Ashley Lynch.
So we had to promise not to sue any of them to get out.
That was part of the deal, according to the sources. He was released after 6 weeks of confinement. So if the sources are accurate, we're not just looking at an isolated arrest, but an alleged forced surrender of his legal rights under duress.
What does this reveal, then, about the vulnerability of individuals when they're facing the full weight of the state like this?
It's a critical insight, isn't it? It illustrates how the very mechanisms designed for justice-like plea bargains can potentially be weaponized, allegedly, to silence dissent and shield officials from accountability. This plea agreement, especially that covenant not to sue, becomes a central piece of the alleged coercion puzzle.
Now, here's another piece of critical federal evidence related to his FOIA activities that really brings the timeline into sharp focus.
Okay.
On July 11, 2017, just 5 days after his guilty plea.
The one he claims was coerced.
Exactly. Another FOIA request, Don USMC 2017-0005-332, received its final disposition from Headquarters Marine Corps FOIA.
Okay, another FOIA response.
The response was sent to an attorney, Charles E. Yao II, with specific instructions from Reardon. Release to the public if anything happens to me.
Wow. That strongly suggests a direct link, doesn't it? Between his ongoing FOIA efforts and the immense pressure he was allegedly under. It's almost like he anticipated further punitive actions.
It really paints a stark picture. It reinforces the idea that his FOIA activities were indeed a catalyst for, well, for everything that followed.
And just one more detail from around that time. Robin Tannehill was elected mayor of Oxford on June 6, 2017. That was the day Reardon was actually scheduled to address the Board of Aldermen, but he was in jail.
Right, because of the stalking arrest?
So his detention directly impacted his ability to engage in that civic action he had planned.
Okay, so what does this all mean legally? This rapid sequence of events, the FOIA grant, the immediate felony arrest, the high bond, the alleged threat, the plea deal with the waiver not to sue, the sources point to a core legal theory, First Amendment retaliation.
Precisely. Filing FOIA requests, even threatening legal action to compel compliance, these are constitutionally protected activities. They fall under the right to petition the government for a redress of grievances.
So the government can't punish you for asking for information or threatening to sue them over it.
That's the principle. The challenge in these cases is often proving causation, proving that the motive behind the arrest was actually his protected FOIA activity and not some legitimate reason.
How do you prove motive?
Well, the sources highlight several facts that strongly support this causal connection, at least according to the legal memo. First, the extraordinary temporal proximity.
The timing again.
Less than 1 day between his final litigation threat to the Marines and the felony stalking arrest. That creates a powerful inference of retaliation. Courts often hold that very close timing can establish a prima facie inference of retaliatory motive, especially when you combine it with other circumstantial evidence.
Like what?
Like the fact that FOIA activity isn't a crime. The sudden invention, as Reardon alleges, of criminal charges right after his protected conduct is highly suspect.
And the alleged baseless nature of the charges themselves, that they were fictitious, as Reardon claims.
That strengthens the argument significantly. If there was no legitimate probable cause for the arrest, that points strongly towards retaliation as the true motive. There's case law, like Hartman v. Moore, which basically says if charges are brought without probable cause, especially right after someone exercises their rights, it suggests a retaliatory motive.
Okay, and the legal memo drew an analogy to another case, Lozman.
Yes, Lozman v. City of Riviera Beach. That's a fascinating case. In Lozman, the Supreme Court allowed a First Amendment claim to proceed even when there might have been probable cause for an arrest, because the plaintiff had evidence that city officials had actually orchestrated his arrest in retaliation for his criticism of them.
So even if there was a technical reason for arrest, if the real reason was retaliation.
Exactly. The sources argue that if direct evidence emerges of a coordinated effort between federal actors, like the Marines, and local actors, like the Sheriff's Department, say, communication from a USMC official urging action against Reardon, it could potentially override a probable cause defense. It suggests a premeditated scheme to silence him, regardless of whether a minor infraction might have technically occurred.
So this isn't just being framed as a collection of unfortunate events. It's presented as a potentially calculated, multi-pronged effort to silence someone trying to hold power accountable.
That's the core allegation.
And this saga, according to the sources, just kept expanding beyond these initial incidents. It took a significant personal toll on Matthew Reardon over several years.
That's a crucial observation. And it brings us to part 3. An expanding saga. The sources outline this persistent series of legal battles, especially around his child custody.
Right, the custody issues continued.
For instance, in September 2017, there was a psychological evaluation done by a Joe Edward Morris, Ph.D. It found Reardon had no significant psychological deficits, called him emotionally stable, and an effective and caring parent.
Okay, that sounds positive for him.
It does. And importantly, the report also noted that coercion was the chief reason for his prior guilty plea on the stalking charge.
So the psychologist agreed it was likely coerced.
That's what the report notated, according to the sources. This directly contradicts any narrative that might have been used to justify the charges or his plea. It's an independent professional assessment.
So a professional assessment basically says this person is stable and his plea was coerced. That's powerful. On the custody front, he was supposed to have visitation with his daughter during Christmas holidays every odd-numbered year based on an agreed order from May 2018. But things quickly went south again, didn't they, with even more serious allegations?
Yes, the sources detail what they describe as a false rape accusation. This is in late 2018.
Okay, what happened?
On November 28, 2018, Phyllis Crowder, on a recorded phone call, allegedly admitted to conspiring with her current husband to falsely accuse Matthew Reardon of rape.
She admitted it on tape.
Allegedly, yes. The next day, Olive Branch police officers were dispatched after Crowder reported a physical assault, alleging sexual assault by Reardon had occurred a few days earlier on November 25th.
And what did the investigation find?
Well, Det Holliday of Olive Branch PD met with Phyllis Crowder on November 30th. She stated she voluntarily removed her own clothing and admitted performing oral sex on Reardon to get him back right, but she maintained the interaction wasn't consensual.
Okay.
Then in mid-December, Matthew Reardon was interviewed. He stated he and Crowder had planned consensual sex via text messages. He provided his cell phone to the police.
And the texts.
The downloaded information, according to the sources, matched the text and supported Reardon's claim of consensual sex.
So the evidence backed him up.
It appears so. Ultimately, Det Holliday concluded the rape allegation was a false report.
A false report officially.
Officially concluded by the detective. Subsequently, around January 2019, the Olive Branch Police Department filed a misdemeanor charge of false reporting of a crime against Phyllis Crowder and issued a warrant for her arrest.
Wow. So the police charged her after investigating her claim against him.
Correct. This is incredibly significant because it's an official finding of a false report from law enforcement. It provides concrete judicial backing to his assertion that he was the target of fabricated allegations. It strengthens the idea of potential malicious intent in the original felony charge as well. It really speaks to the credibility or alleged lack thereof of the complaints filed against him throughout this saga.
Yet, despite this official finding that she filed a false report, the allegations against Reardon didn't stop.
Apparently not. On January 24, 2020, Phyllis Crowder reported to a deputy, Brian Howell, that their daughter, Lydia, stated, quote, "Mommy Maddie hit me really hard because I didn't eat all my sandwich." Phyllis contacted Child Protective Services and filed a report.
Another serious allegation.
Yes. The very next day, January 25, 2020, while another deputy was actually talking to Reardon about his ex-girlfriend trying to file false police reports.
All right.
Patrol Officer S. George of Olive Branch PD took custody of Phyllis Crowder for that outstanding warrant for false reporting of crime.
Ah, so they finally arrested her on the warrant from the rape claim.
Yes. She bonded out later that day.
And what happened with that charge against her?
Here's the resolution. On September 22, 2020, Phyllis Crowder was convicted in Olive Branch Municipal Court for false reporting of a crime.
So found guilty by a court.
A court conviction, reinforcing the claim of fabricated allegations. Despite this conviction, Crowder continued her attempts to modify custody.
Even after being convicted of lying to the police about him.
According to the timeline, yes. On August 26, 2020, she filed a petition with what Reardon calls false allegations to modify the custody order and reduce his rights. He characterized it as a completely frivolous filing. A month later, September 30, 2020, she filed another petition for modification and contempt, allegedly duplicating the August 26 affidavit.
It sounds relentless.
It suggests a persistent, maybe even vexatious, stream of legal action against him. Then, on October 8, 2020, Mrs. Kester, as Crowder was referred to, then filed an emergency petition for contempt, custody modification, child support, and injunctive relief.
Emergency petition. Okay.
A temporary order was issued on November 16, 2020. It basically continued the matter, allowed Reardon supervised visitation, reduced his child support to $400 a month, and appointed a guardian ad litem, or GAL.
A GAL usually means the court is concerned about the child's best interests when parents are fighting like this.
Exactly. It signifies high conflict. And it's important to note that on November 19, 2020, Phyllis Crowder filed her conviction for false reporting of a crime.
The one she was just convicted of.
Yes, but that appeal was later dismissed because it wasn't filed on time, so the conviction stood. This persistent pattern of alleged false reporting and her actual conviction for it is a critical piece of evidence regarding the credibility of complaints against Mr. Reardon.
Okay, so amidst all these custody battles and these alleged false accusations, Reardon was also trying to fight back on his original aggravated stalking charge, right? Trying to get evidence.
Yes, absolutely. He was actively trying to uncover evidence and appeal that 2017 conviction.
Huh.
On May 20, 2020, he submitted a public records request to the Lafayette County Sheriff's Department. He asked for the original affidavit police report alleging aggravated stalking on Todd and Ashley Lynch from May 2017.
The very first document that started the felony charge.
Exactly. What he received back was a post-arrest narrative dated May 30, 2017. Not the original report. He stated this narrative was made 4 days after his arrest and just before his bond hearing.
So not the original complaint affidavit.
No. This suggests a critical missing document, potentially the foundational document for the charge, and it further raises questions about the origins and legitimacy of that stalking charge.
And this is directly relevant to the due process allegations we talked about earlier.
Precisely. He then pursued post-conviction relief, or PCR, trying to challenge the conviction itself. On June 1, 2020, Reardon emailed Kathy Sturdivant, Judge Luther's administrator, asking for direction on his case. He cited inadequate representation by his previous lawyer and expressed concern about the statute of limitations running out and also about the potential destruction of evidence.
What evidence was he worried about?
He specifically mentioned the missing FBI 302 form from his interview and the recording of the sheriff's phone call from May 24, 2017, the very evidence he said he had provided to the FBI that allegedly went missing.
Okay, so he's trying to preserve this potentially crucial evidence. Did the PCR go anywhere?
Well, on July 30, 2020, Judge Kelly Luther denied his initial PCR motion without even holding an evidentiary hearing.
Denied without a hearing.
Yes. Reardon then filed a motion for rehearing on August 10th. And just 2 days later, August 12th, he filed a motion for recusal, asking Judge John Kelly Luther to step aside due to an alleged conflict of interest.
A conflict of interest with the judge.
That was his allegation. And here's another twist. Reardon claimed the assigned judge on his PCR case was fraudulently changed in the system from Judge Kent Smith to Judge John Kelly Luther after he filed that recusal motion against Luther.
Wait, the judge was switched after he asked for that judge to be recused?
That's the claim. If true, that's an extremely serious allegation about judicial integrity and potential manipulation of the system.
Absolutely. What happened with the rehearing motion?
On October 13th, 2020, Judge Luther denied Reardon's motion for rehearing, even though, according to Reardon, the case was supposed to be assigned to Judge Kent Smith by then.
So the judge he asked to be recused ruled on his motion anyway.
That's what the timeline states. It raises serious questions about the judicial process and alleged manipulation of case assignments, adding another layer to the systemic challenges Mr. Reardon reportedly faced.
In parallel with all this, Matthew Reardon was making it clear he intended to sue, right, in federal court.
Yes, he was very upfront about it. On June 25, 2020, he messaged Christy McCoy, who was Crowder's attorney at the time. He discussed his belief in the false reports, alleged a criminal conspiracy by the Lafayette County Sheriff's Department, and stated his intention to file for post-conviction relief and a federal lawsuit.
Putting them on notice.
Clearly. Then, on July 1, 2020, he informed David O'Donnell, the Lafayette County attorney, of impending legal action. This included a federal civil rights lawsuit, and he explicitly named names. Sheriff Joey East, Mayor Robin Tannehill, Rhea Tannehill, Brennan Horan, his former attorney, Scott Mills, Alan Wilburn, Jared Bundren, Caleb East, and Phyllis Liz Crowder as defendants.
So he's basically calling out everyone he believes wronged him?
He's putting the alleged conspirators on notice, indicating his intent to seek legal redress for the perceived violations. He's not just reacting anymore. He's proactively challenging the system.
But this didn't stop further arrests, did it?
Apparently not. On December 27, 2020, Reardon sent an email titled Criminal Conspiracy to Sheriff Joey East, reporting alleged crimes involving the harboring and exploitation of his child.
Okay, reporting crimes to the sheriff.
The very next day, December 28, 2020, Reardon went to the Lafayette County Sheriff's Department in person to seek assistance regarding these alleged crimes. He was arrested for disorderly conduct and resisting arrest after reportedly refusing to move his vehicle without speaking directly to Sheriff East first.
Arrested for trying to report a crime to the sheriff he just emailed.
That's the sequence of events presented.
Yeah.
He was held until December 30, 2020. He was released only after Sheriff East personally approved his bond, apparently 24 hours after his spouse and a bonding agent were initially turned away.
It seems like the cycle of alleged harassment and arrest just continued anytime he tried to raise concerns.
It reinforces that pattern of immediate repercussions following his attempts to raise concerns or report issues. Fast forward to February 21, 2021. Reardon gets pulled over by deputies Candace Beavers and Jake Williford around 3:00 a.m.
Okay, another traffic stop.
Beavers claims she smelled marijuana. Reardon was taken to jail. No field sobriety tests were done, supposedly due to weather. Williford searched the vehicle but found no contraband.
No drugs found, but he was still charged.
Yes. Charged with DUI other, meaning under the influence of something other than alcohol, improper equipment, and an expired tag.
Amidst these new charges, though, there was some kind of agreement in the custody case.
Yes, an agreed order was entered in Chancery Court on March 23, 2021. In this order, Reardon rescinded a counterclaim he had filed against Crowder-Kester, and she withdrew a criminal complaint she had filed against Reardon back in February 2020.
Okay, a bit of de-escalation.
It seems like an attempt. Child support stayed at $400 a month. The GAL was dismissed. And critically, both parties agreed not to communicate grievances to CP. Seemingly an attempt to curb the ongoing disputes, maybe aim for a fresh start in the custody realm.
Yet, despite that agreement, things didn't stay calm.
According to Reardon, no. He claims Crowder completely denied him access to Lydia in May 2021, violating that order. He further alleged that on June 5, 2021, Crowder just abruptly ceased all communication and visitation.
So the agreement didn't hold.
Apparently not from his perspective. A couple weeks later, June 19, 2021, deputies responded to a disturbance call at Crowder's address. Reardon told them he went there to get his daughter for Father's Day, was told to get off the property, and then admitted he told Crowder to fuck off. He claimed he had everything on camera.
So the conflict continues even after an agreement. It highlights how deeply entrenched these battles were.
It's clear the personal and legal struggles persisted, even intensified. Then, on July 1, 2021, Matthew Reardon obtained press credentials.
Press credentials.
Yeah.
As a journalist.
Yes, as a credentialed reporter, photographer, and journalist with the Constitution First Amendment Press Association, CFAPA.org. This is a significant development. It sort of solidifies his role as a public information seeker and government critic. It seems like an attempt to leverage the protections afforded to journalists for his ongoing investigations.
Interesting move. Did it change how authorities interacted with him?
Well, the alleged harassment continued. Just over a month later, August 10, 2021, Phyllis Crowder filed yet another petition for modification and contempt.
Another one.
Then on September 14, 2021, Reardon was ordered by the court to immediately submit to a nail-bed drug test, and his visitation was suspended until further order.
Why? What was the basis for that?
According to the sources, it was due to a baseless paraphernalia charge in Calhoun County that had actually been dismissed months prior.
Based on a dismissed charge.
That's the claim. Reardon noticed the court he intended to appeal this on 4th, 5th, and 14th Amendment grounds. The legal challenges just keep piling up.
And there was an incident with a drone?
Yes. On September 29, 2021, Reardon flew a small aerial drone near the Justice Court building. It apparently clipped the building and crash-landed. Chief Deputy Scott Mills and other Oxford police officers arrived.
Okay.
Mills reportedly asked Reardon if he had a commercial license for the drone, specifically citing Reardon's press credentials. And Reardon was apparently harassed for his physical home address.
So they brought up his press credentials in relation to the drone.
It suggests ongoing scrutiny, perhaps even targeting of his actions, maybe heightened by his new journalist status.
All these incidents, the email arrest, the DUI, the drone, they culminated in a big trial, right?
Yes, a major trial on November 4th, 2021 in Lafayette County Justice Court. Matthew Reardon went to trial for 9 separate charges, stemming from 3 separate events.
9 charges at once.
The disorderly conduct and resisting arrest from the December 2020 incident at the sheriff's office, and the DUI other, improper equipment, and expired tag for the February 2021 traffic stop. A significant legal showdown consolidating multiple alleged infractions.
And what happened during the trial? Were there issues?
According to the sources, yes. There were serious allegations regarding testimony and evidence. Deputies Beavers and Williford reportedly claimed ignorance about missing video evidence of the field sobriety tests in the DUI trial. Sheriff Joey East apparently stated the footage was gone forever.
Missing evidence again.
Missing evidence again. Furthermore, the testimony of Deputies Dixon and Tidwell in the disorderly conduct resisting arrest trial was allegedly perjured. Reardon claimed he had audio documentary proof contradicting their testimony.
Audio proof of perjury.
That's his claim. Sheriff Joey East also testified, stating he heard what sounded like a female being assaulted in the parking lot during Reardon's December 2020 arrest. These alleged instances of missing evidence and perjured testimony, if proven, would be significant due process violations.
So what was the verdict after all that?
Reardon was found guilty on all charges brought by the Lafayette County Sheriff's Department, but he was found not guilty on all charges brought by Crowder.
Interesting. Guilty on the police charges, not guilty on the ex-partner's charges.
It's a split decision, but the charges from law enforcement stuck. It sent a clear message, perhaps, about who held power in that courtroom.
This cycle of alleged harassment and arrest then escalated even further, didn't it, to involuntary commitments?
Yes, this is a particularly disturbing phase outlined in the sources. On December 6, 2021, Matthew Reardon discovered that the assigned judge for his appeal of those convictions, Judge Kent Smith, had apparently been changed in the court system to Judge John Kelly Luther.
The same judge he tried to recuse before.
The very same one. He confronted the circuit court clerk, Jeff Busby, about this. Busby allegedly became defensive and called Sheriff Joey East.
The sheriff got involved over a question about the judge assignment.
Apparently. Sheriff East arrived, reportedly blocked Reardon's vehicle, and ordered him not to go back into the circuit court unless he had something specific to file, claiming he was disturbing their business.
Wow. And then?
The very next day, December 7, 2021, Sheriff Joey East allegedly reported knowingly false and damning statements about Reardon to a Communicare employee named Rachel Alcorn. Communicare is a local mental health provider. The purpose, allegedly, was to seek judicial commitment of Matthew Reardon.
Using the mental health system against him.
That's the allegation. An affidavit for his commitment was approved and signed by Judge Lawrence Little. 2 deputies located Reardon, took him into custody, and he was involuntarily committed.
Just like that, based on the sheriff's report.
Based on the affidavit signed by the judge, which was allegedly based on false information from the sheriff. 2 days later, December 9, 2021, he was involuntarily committed to a state hospital facility in Tupelo, Mississippi. The severity of these involuntary commitments is striking. How does this alleged misuse of mental health processes fit into the bigger picture?
Yeah. How does it factor into the broader legal claims of persecution?
According to the sources and the legal memo, this adds another powerful layer to the due process violations claims. It's presented as an alleged abuse of a system designed to protect people, not to silence or punish them. It speaks to the extraordinary lengths allegedly taken to marginalize Mr. Reardon and undermine his credibility, especially as he was actively challenging the authorities. It's framed as a profound alleged perversion of state power.
He was discharged eventually.
Yes, discharged on December 23, 2021, with a follow-up appointment scheduled. On December 30th, Reardon contacted Rachel Alcorn from Communicare. He discovered, or confirmed, that the Lafayette County Sheriff's Department, particularly Sheriff East, was allegedly behind the information that led to that commitment affidavit.
So he got confirmation it traced back to the sheriff.
That's what the sources state, linking the commitment directly to the sheriff's alleged actions, moving it from just a commitment to potentially a specific targeted act.
But the commitments didn't stop there, did they?
No. The pattern allegedly continued. On January 4th, 2022, Reardon signed and filed an affidavit declaration of truth against Sheriff Joseph B. East, detailing alleged constitutional violations and sedition.
Okay, doubling down on his accusations against the sheriff.
Yes. On February 7th, 2022, He sent a formal complaint to Dr. Sandy Rogers, the executive director of Communicare, copying Chancellor Lawrence Little. He alleged fraudulent involuntary judicial commitment stemming from false information provided by Sheriff Joey East. He explicitly stated this was the second time a court record had been fraudulently altered regarding his cases.
He's alleging fraud directly to the head of the mental health agency and the judge.
Correct. Then, just 2 days later, February 9, 2022, another Communicare employee, Susan Beard, filed another affidavit for Reardon's commitment. This time, the claim was that he refused to attend a scheduled appointment.
Committed for missing an appointment.
That was the basis for the second affidavit, yes. The very next day, February 10th, Reardon was picked up again by Lafayette County Sheriff's deputies based on this new commitment writ. He was held and reportedly made threats while resisting instructions during booking.
So a second commitment within 2 months of the first.
Yes. It cements this pattern of alleged misuse of the mental health system against him.
And the personal toll during the second commitment was particularly severe, wasn't it?
It was profound. On February 17, 2022, while Reardon was confined at the East Mississippi State Hospital, his son Ethan was born. It was via emergency C-section at only 28 weeks gestational age, weighing just over 2 pounds.
Oh my goodness. While he was locked up in a state hospital.
Yes. He was denied the ability to leave, even for emergency purposes, to see his wife and his critically premature son. Ethan remained in the NICU for months, requiring extensive medical care. Reardon was finally discharged from the hospital on March 19, 2022. This personal toll, the birth of his son while he was allegedly unjustly confined, it adds a deeply human and tragic dimension to this story. It truly underscores the profound impact these alleged legal machinations had on his entire family.
It's just a stark reminder that behind every legal document, every court order, there are real lives, real families, and immense personal suffering when due process is allegedly perverted.
Absolutely.
After this harrowing period, what happened legally? Did his appeal go anywhere?
No. On April 1, 2022, the Lafayette County Circuit Court dismissed Matthew Reardon's appeal of the November 2021 convictions as untimely. The Chancery Court also issued an order stating his visitation with his minor child remains suspended.
So state avenues seemed closed off.
Pretty much. So Reardon turned to the federal system. On April 6, 2022, Matthew Reardon filed an initial federal complaint in the U.S. District Court for the Northern District of Mississippi.
The lawsuit he'd been threatening.
Exactly. Alleging numerous constitutional rights violations, false imprisonment, malicious prosecution, abuse of process, wrongful interference with familial relationships, loss of consortium. He named a broad range of defendants: the state of Mississippi, Lafayette County, the Sheriff's Department, Chancery Court, Communicare, Sheriff Joseph B. East, David O'Donnell, Sherry Wall, Jeff Busby, Dr. Sandy Rogers, Rachel Alcorn, Susan Beard, and John Doe deputies.
A huge lawsuit. Naming everyone.
A comprehensive federal lawsuit laying out the full extent of his alleged grievances over years.
But filing the federal lawsuit didn't stop the arrests either.
Apparently not. On June 20, 2022, Deputy Tyler Wren received a call about a suspicious incident at the Justice Court. It was Matthew Reardon attempting to film the lobby, stating he was a journalist.
Filming in a public lobby.
Then, on June 28, 2022, Deputy Hobie James served an arrest warrant on Matthew Reardon for warrant served for other agency felony. He was transported back to the Lafayette County Detention Center, all while his premature son Ethan still required significant medical care.
What was this felony warrant for?
The timeline doesn't specify the underlying charge for that particular warrant service, just that it was a felony warrant served for another agency.
Okay. He got a lawyer.
Yes, Mitchell Driscoll was appointed as Reardon's public defender. He took detailed notes, including, importantly, notes about Reardon's wife's employment. This detail becomes strikingly relevant very soon.
Okay, how so? This is where things get murky with the lawyer.
Yes, this is where the narrative introduces alleged attorney misconduct and its devastating financial impact. 2 to 3 weeks after a preliminary hearing on July 5, 2022, Mitchell Driscoll just abruptly ceased communication with Matthew Reardon. He informed Reardon that another lawyer, Mark McClinton, would be taking over his case.
Just dropped him.
That's how it's presented. Then, on August 15, 2022, Mitchell Driscoll, Reardon's former public defender, started working at Rhea Tannehill's law firm.
Wait, Rhea Tannehill? The person who allegedly threatened him in the courthouse and who...
Matthew Reardon.
So I got to pause it there for a second because I realized, and this is what's really awesome is, in order to put it on this right here. With the deep dive right there, I've fed in all of the court documents. I've fed in document links, and for whatever reason, it somehow skipped over that key part. I was just, it just generated this thing, and I was, it's factual. It reads the documents, but what happened right there was I had June 20th, 2022. I went into City Hall. I was gonna make a public record request, and I was also doing I was filming the inside of City Hall, and this bogus 2017 restraining order that I can 100% prove was fraud committed on the court and complete lies. Complete lies. It was used as a prior restraint, and they took complete advantage of it a second time by charging me with aggravated stalking just for simply being inside a city hall. Just for going in there. Didn't see the mayor, didn't ask for the mayor, nothing. And just fucked my life up to pieces once again. Once again. So I had to stop it for a second and interject that part right there. Let's hear what it has to say now.
He mentioned to the FBI. His lawyer went to work for her firm.
That's what the timeline states. A significant move, given Rhea Tannehill's alleged past involvement and Reardon's prior reporting about her.
That seems like a massive conflict of interest, or at least the appearance of one.
It certainly raises serious questions.
Yeah.
And just a few weeks later, third or fourth week of August 2022,
Yes.
Matthew Reardon's wife lost her job. This coincided with his ongoing detention and created a huge financial crisis for the family. They had 4 children to provide for, and Ethan was still requiring medical care.
And this happened right after his former lawyer, Driscoll,
Who had detailed notes about her employment.
started working at Rhea Tannehill's law firm.
The timing, as the sources point out, is presented as very suggestive of potential strategic disadvantage being leveraged against him and his family.
Wow. Under all that pressure, incarcerated, wife lost her job, sick child, he faced another plea bargain.
Yes. On September 30th, 2022, he was led into what the sources call an ambush meeting with his new attorney, Mark McClinton.
An ambush meeting.
Clinton reportedly advised him to plead out to the current charge. The reasoning given was to get out of jail so he could care for his hospitalized child and provide for his family. McClinton apparently stated the state would not drop the charge and would likely taint a jury pool even if the case were moved to another jurisdiction.
So plead guilty to get out and help your family. That sounds like extreme pressure.
It portrays a clear picture of duress, aligning with his earlier claims of coercion back in 2017.
But the alleged retaliation didn't end even after that plea.
Apparently not. On October 28, 2022, Reardon called and spoke to the FBI again, this time to report alleged law enforcement corruption involving 2 agencies.
Reporting corruption to the FBI again.
Yes, he had evidence he wanted to bring. And, importantly, following the terms of his banishment agreement, which allowed entry for official purposes, he contacted the Lafayette County Sheriff's Department in advance of his FBI visit. He spoke to Deputy Candace Beavers and told her everything verbatim about his planned FBI visit. This phone call was reportedly recorded.
Why is the recording of that call important?
Because of what allegedly happened next. This detail is crucial for the claims of perjury that follow.
Okay, so he told the sheriff's deputy he was going to the FBI as required. What happened?
This direct contact with federal authorities about corruption appears to have triggered immediate repercussions. On November 1st, 2022, Matthew Reardon was pulled over by Deputy Hobie James. He was returning from a Holly Springs, Mississippi City Council meeting where he had been speaking out publicly.
Pulled over right after planning to go to the FBI.
Yes. He was abruptly arrested for probation revocation and held in jail until November 3rd.
Probation revocation. On what grounds?
At the probation revocation hearing on November 3rd, 2022, Reardon learned that Deputy Candace Beavers, the one he spoke to on the recorded call, allegedly lied under oath in court about that conversation. She claimed he had violated the banishment clause by being in the county without permission.
But he called her first, and it was recorded.
Exactly. Despite apparently following the proper procedures for reporting crimes to federal law enforcement, Reardon was sentenced to prison for 1 year for allegedly violating his banishment. The sources characterize this as direct punishment for reporting law enforcement corruption to the FBI.
Sent to prison for a year based on alleged perjury about a recorded call.
That's the allegation. The immediate and severe consequence for reporting alleged corruption is presented as a chilling insight into the alleged power dynamics.
Did he serve the year?
He did. On August 1st, 2023, Reardon was released from the East Mississippi Correctional Facility. The very next day, August 2nd, he publicly exposed Deputy Beaver's alleged lies on the stand that had sent him to prison, directly challenging the integrity of the system.
Okay, so he's out and immediately trying to clear his name. What did he do next?
Seeking a fresh start and also continuing his investigative work, on August 10th, 2023, Matthew Reardon decided to travel to Galveston, Texas. He planned to investigate the Galveston Police Department for alleged corruption.
Taking his fight to another state?
Seems so. However, the very next day, August 11, 2023, he was arrested in Galveston, Texas on a felony DWI charge.
Arrested again, this time in Texas. Felony DWI.
Yes. He alleges this was orchestrated by Texas and Mississippi officials, specifically naming deputies Janes and Beavers from Lafayette County and Circuit Clerk Jeff Busby, using fabricated evidence and a warrant obtained through alleged perjury by the arresting Galveston officer, Officer Osteen. He claims a false enhancement was used to turn what should have been a misdemeanor DWI into a felony.
How could Mississippi officials orchestrate an arrest in Texas?
Well, the sources detail alleged coordination. Lafayette County Deputy Hobie James apparently called Galveston PD dispatch at 2:41 a.m. on the night of the arrest. Then Deputy Candace Beavers called Galveston PD at 4:04 a.m. to, quote, reinforce false criminal history information.
So Mississippi deputies were calling Galveston PD while he was being arrested.
That's the allegation. Matthew Reardon was incarcerated in Galveston under a $100,000 bond. This interstate coordination, if proven, would be critical evidence for a broader conspiracy claim, showing the alleged reach of the efforts against him.
What happened with the Texas charge?
Eventually, the Galveston District Attorney's Office dropped the felony DWI charge on May 24, 2024. They recharged it as a misdemeanor.
So the felony part was dropped, but he was still extradited.
Yes. Despite the charge reduction, Reardon was extradited from Galveston back to Lafayette County, Mississippi on June 24, 2024.
Back to Mississippi, why?
For another probation revocation hearing. On July 18, 2024, Reardon's unsupervised probation was revoked, and he was sentenced to 2 years in prison.
2 years. Based on what this time?
According to the sources, it was based upon alleged lies given by the Galveston officer, William Osteen, who reportedly intentionally misrepresented key facts while testifying via Zoom at the revocation hearing back in Mississippi.
So sentenced to 2 years in Mississippi based on testimony from the Texas officer whose felony charge was dropped.
That appears to be the sequence of events described.
This timeline is just relentless. Did that sentence stand?
No. Here's another major turn. On January 25, 2025, Reardon's 2-year prison sentence was vacated and declared unlawful by the court. This happened after the MacArthur Justice Center filed a comprehensive post-conviction relief motion on his behalf.
Vacated, declared unlawful, so the court agreed the sentence was wrong.
It appears so. A significant reversal, affirming his long-held claims of unjust incarceration, at least for that specific sentence. The very next day, January 2010, 2025, Matthew Reardon was released from prison at the Mississippi State Penitentiary in Parchman.
Finally out again. What did he do? Did he stay in Mississippi?
No. With this new freedom, he relocated, moved to Layton, Utah on February 1st, 2025, seemingly seeking to distance himself from the alleged persecution in Mississippi.
A fresh start in Utah. Did it work? Did the alleged harassment stop?
The sources suggest no. The alleged surveillance and harassment reportedly followed him. On February 21st, 2025, Reardon received a call from a defendant, Mark Arrington, who referred to him as Matthew, even though Reardon had apparently used the name Don in prior communications with him.
How did he know his real name?
A small detail, perhaps, but one that raises questions about how Arrington knew his given name if their prior communication was under an alias. Then, in early March 2025, Layton City officials in Utah allegedly stonewalled Reardon's public records requests. He was looking for interdepartmental communication about his relocation and any information being disseminated about him.
Stonewalled on records requests in Utah now.
That's the claim. He claims to have discovered that a Captain Hilton Sessoms ran illegal interstate surveillance on him and his new Utah address within just hours or days of him relocating there.
Illegal interstate surveillance? That's a huge allegation.
A profound claim of continued cross-state monitoring. On March 27, 2025, Matthew Reardon apparently had a phone call with the Layton Chief of Police, Jeff McCutcheon, explicitly detailing Captain Sessom's alleged unlawful acquisition of his private information.
He confronted the chief about it.
Yes. Then, on March 31st, 2025, Reardon went to the FBI's Salt Lake City field office. He wanted to deliver an affidavit alleging misconduct by Captain Hilton Sessoms.
Trying the FBI again, in Utah.
He was told he couldn't submit the affidavit without undergoing a background check first. He began recording video in the public visitor parking lot outside the FBI office. 2 FBI agents approached him, demanded he cease recording, and threatened him with arrest for trespassing on federal property.
Threatened with...
So, hold on one second. I had to pause it right there, and I accidentally ended up stopping it. So I gotta find where it was at. I wanted to shoot. It's not letting me trim it. I wanted to stop it right there and actually point out that it got the names wrong. It's Captain Jeff McCutcheon from Oxford Police, and it's Chief Jeff McCutcheon from Oxford Police and Captain Hilton Sessoms from Oxford Police. It had, I guess, mixed that up, and I'm trying to, as I catch little things like that, and there was something. I have to go back there and jot that down. I know it was about 50 minutes into it.
Imagine a person's life just turning into this relentless
cannot,
legal battle. I mean, escalating from...
Yeah, I'm not going to start it over right there. Yeah, what's important is, the stuff right there at the beginning and how it got to the stuff that's going on right now. I just thought that was something pretty cool right there that that I could actually, it's called Notebook LM. If you have a lot of documents, you can actually feed it into it, and it can help, basically organize everything. And obviously, I've got a mountain of shit that's just accumulated over the past 8 years. And there's a lot of things that I'm seeing now, the connection to making this public record request back in April of 2017, the connections to a lot of the things that are going on right now. Yeah, I want answers. And I'm not going to stop until I get answers. Okay. It's got to happen. It's got to happen. I got to have some kind of accountability for this, because this is, flat wrong. So, yep. Well, I'm gonna get off of here, and I've been sitting for a little